All right, I think we're live. Hey, everybody. Hey, Amy.
Hi, Danielle. You
How
ready
you?
to rock and roll?
I am. I got the links pulled up. I'm going to wait to see how many people are in chat. It's delayed a little bit on telling me. So I need to see how many people are down there to see if I need to slow the chat down. So that might take me a moment.
I am sending a quick email.
Yeah. Everybody who's
awesome.
new, thank you for joining us. We appreciate you being here. And of course, to everybody who's been with us and hung out with us many times here on YouTube, it's good to see you again and talk with you. Yeah, I'm going to slow the chat. So give me just 1 minute, guys. I'm going to slow the chat down so that
No problem.
everybody gets a chance to talk here.
While we're doing that, while we're slowing the chat, if everybody can give us a sound check and let us know we sound okay on your end, that would be great.
Yes, please. Thank you. Hey, Lonesome Dove. I'm trying to watch all your comments. Yeah. Maui girls.
And I'm going to say this name right tonight. Humanimal. Humanimal. Yes, got it.
That's a tongue twister,
I was calling you a human animal the other night.
That's funny.
It is. Like,
yay, we got the thumbs up on sound. Thanks, guys, for letting us know our audio is good. So,
good.
Hey, Irish. Anybody who's new down there, our mods are amazing. I think many of them are down there tonight. They're all amazing. Please treat them all with respect. And we're going to start off with, oh no, I just did something I didn't mean to do. Web Sleuth, could you re-comment? Web Sleuth, I'm so sorry. I got a little frazzled there for a minute. Anyways, so we're going to start off with the rules here on our channel. For everybody who's new, we stick to some pretty basic standards here. We do not talk about other channels unless, for example, Web Sleuth is down in the chat. It's great to talk about Web Sleuth. We love Trisha. We support Web Sleuth. But we don't discuss other channels. We don't discuss drama. We don't discuss social media, Facebook groups, no negative talk about anybody. We try to stay focused on the case because that's what we're here for. And just not bringing any of that in eliminates a lot of problems. So that's how we like to do things.
Danielle, real quick.
Go ahead.
Danielle?
Yep, I'm here.
Oh, okay. I didn't know if you can hear me or not.
Yeah.
They're saying They're saying that I'm echoing, and I can barely understand you on my end because there's static. I need to go out and come back in. I'm so sorry.
That's okay. And if you've never been to our channel, go ahead.
All right. So
if you've never been here before, StreamYard does not like us. So sometimes we got to go back, come back in. It sucks a little bit, but it's what we do. Yeah, the rules are common sense. Just be respectful. We don't support bashing or talking in any way about any other creator or Facebook group or anything like that. The mods will be sharing links down in the chat throughout this live. And we're going to wait for Amy to rejoin. I'm just trying to kind of watch her comments here. I know Trisha from Web Sleuth is amazing. I accidentally deleted her comment and I did not mean to. I'm so sorry, Trisha. Yes. Amy's on her way back. My audio isn't good. Okay. So I'll add Amy in. And I guess I will leave and come back if my audio is not good. Just gotta get her here. Oh, I sound fine? Okay. Thank you for letting me know. Bear with us a moment, guys. Sorry. Okay. Amy is back, and we're going to get started. Again, round 2.
Okay. Sorry
All
about
right.
that.
No problem. No problem.
It's crazy.
There's lots and lots of questions, you guys, down in the chat. And I think what Amy and I are going to do tonight is we're going to focus on reading these documents. And we are going to get to all of your questions. I promise you, we're going to do our best. We have had to throw a lot together in a very short amount of time. So I apologize if I'm a little frazzled or seem a little overwhelmed here. It's been a crazy 24 hours.
It's been a crazy 72 hours.
It has been a crazy
And
72 hours. I can't even speak.
it is
72 hours.
yeah.
So,
And as quickly as we're trying to get information out to you, we are receiving information in the same way. So it's just becoming a little hectic. Bear with us. Kind of our dynamic.
yes. And I would like to let everybody know
It's gonna be fun.
Yes. Everybody who is signed up on Patreon, you will be getting your link when this live is over that was specified in our post that we made about it. Depending on your tier. And then we have more documents that are actually going to be coming tomorrow that we will also be putting on Patreon as well and discussing this week and all that good stuff. So I don't know if they will be on Patreon tomorrow, but that's another set of like 90-ish, right, Amy? 90, I think it is.
Right? Yes.
So,
yeah. You'll all be reading for days.
Thank you guys for the super chat. Yeah, thank you, Kathy. You guys are going to have a lot of reading to do. Lonesome Dove, no information on Gannon Stouck's case. I promise you, though, he stole my heart. And as soon as we have more information on his case, we will be live about it, of course. I know Harley was live on Instagram last night, but I don't really want to come on YouTube and talk about Harley at the moment. So,
either. Rose, thank you for the super chat. Thank you.
Yes, thank you, Rose. So we're going to get started. I'm going to share my screen and show the docs. And we're going to start on certain pages. I would like to give everybody a forewarning. The information that we are going to discuss is very sensitive. Parts of it are very graphic. Parts of it are very hard to hear. If you are around any children listening to this, I would suggest that you don't let your kids hear this. Any minor children, young children. There will be parts of this discussed that are hard for us to even read and comprehend. So bear with us if we struggle with any of this. And I guess we'll get the show on the road. Are you ready, Amy?
Yeah, I think it's also, just so you guys know, I'm ready. I want them all to know, though, that when we receive this document, nothing that we're reading to you tonight was redacted. We're telling you exactly what is public record. So just please, please, please keep that in mind.
Yes, these are not our words. These are not things that we have said. These are legal court documents. And might I add, I will add this in because I've seen this comment made quite a few times. They were obtained legally. We operate our YouTube channel much like a media source. We hold ourselves to a higher standard of integrity and character, and we would never do anything illegal to obtain documents. How people think we would obtain them illegally is kind of entertaining, to be honest with you, because we don't have superpowers to make that happen. But just to put it out there, they were legal.
Right. We're very ethical.
Yes. We are. I think I replied earlier and let somebody know.
We're
We
very, very ethical.
we are professional we have professional real lives and professional YouTube lives here. We're not doing anything unethical or would never do anything unethical. So give me just a moment and I'll get the document pulled up and see what we were doing. And thank you guys all for the super chats. You're amazing. All right.
Yeah.
And
So while Danielle pulls that up. Hello?
can you hear me? I don't think Amy can hear me. All right, 3 seconds. I'll be back. All right, can you guys hear me? Amy got kicked off right as I was coming in. This is crazy that we've never had this many problems. I'm going to go ahead and pull the documents up really quick. Amy will be right back. Sorry for the technical difficulties. I think we will be canceling our StreamYard subscription because this is crazy. Crazy. All right, maybe we'll be okay now, Amy, after like 3 tries. So
I'm not going to touch anything.
it's crazy, right? Crazy. My document's loading.
I'm having it. Okay, I'm having a difficult time tonight. I cannot hear you. I can hear like every third word that you say. I'm just going to work with it.
Okay. Can everybody else hear me? Yeah,
It's got to be me. I'm so sorry. So I'm going to roll with it. It's cool. We're cool. I can do this.
Is it your service maybe?
No.
Okay, they can hear us, so we'll just wing this and I'll text you and we'll figure it out. Like, hey, you jumped to this page. You guys, the documents are loading. How this document file's like 1.6 gigs. So it's taking a second to load. As soon as it loads, I will get it up on the screen and we will begin going through what we want to go through. Amy's cutting out, they're saying.
Yeah, there's something wrong on my end. Okay, while you're loading the documents, let me try going on another device. And that's it. Then that's the last time.
Okay. No problem.
All right. Okay.
All right, I got the documents up. So we'll share those and get them up there on the screen. First of all, the fact that this is you guys can see right here, 1,771 pages. The fact that this is a divorce and a custody dispute and it's 1.6 gigs is unreal. I've never seen anything like it. It's pretty crazy. So, Amy's back. All right. Hopefully you're good now, Amy.
I am. I can hear you loud and clear. It was what I was using before. My apologies to everyone.
All right. So I think we're good. What page you want to start on?
Well, I think we should probably. So when we left last time, we were somewhere around 252. Probably need to go through the beginning. Let's just start from the beginning and go through in order until we catch back up to where we were.
So back to 252?
No, from like how the document starts. So hold on. The first document is the order transferring suit affecting parent-child relationship.
Right. So, okay.
Unless you have if you have a different idea, I'm going to go with whatever you.
Yeah, I can read. You just want me to read the first page? Is that what you're saying?
I think we can kind of go over what it contains, just so that they understand. Like when you open this file, this is the first thing. This is how it starts. It starts with an order, and then it gives some directives, and we can kind of like highlight those, and then catch back up to where we were.
Okay. All right. So the very first page of this file is the order transferring suit affecting parent-child relationship. It is in the interest of Tylee, Ashlyn, Ryan, a child. And it goes on to say the court, after considering the pleadings, finds that no controverting affidavit has been filed and that the respective motions to transfer filed by Joseph Anthony Ryan Jr. and Lori Noreen Ryan should be granted. It is therefore ordered that the suit is transferred to Travis County, Texas. The district clerk in that county is ordered to file and docket the case in the appropriate court order under the same procedures as those used for filing an original action. The clerk of this court is ordered to transmit immediately the pleadings in the pending proceedings and any other document specifically requested by a party, certified copies of all entries in the minutes, and a certified copy of each final order to the court designated above in accordance with the provisions of the Texas Family Code. The clerk of this court is ordered to keep a copy of the transferred pleadings and other requested documents. It is ordered and decreed that all child support payments shall be made by Joseph Anthony Ryan Jr. through the Texas State Child Support Disbursement Unit, P.O. Box 659791. Hold on one moment.
What's wrong?
P.O. Box 659791, San Antonio, Texas 78265-9791, and then promptly remitted to that agency by Lori Noreen Ryan for the support of the children. The clerk of this court is ordered to send a certified copy of this order to Lori Noreen Ryan, Joseph Anthony Ryan Jr., and the State Disbursement Unit. All posts, including certified or other copying expenses and postage, are taxed, I can't read that writing, against Joseph Anthony Ryan Jr., for which let execution issue. So that's basically how it begins. And we went over quite a bit in our last live. You guys are welcome to listen to the replay. We went over some psychosexual, I don't even know the right word for what they were. It was psychosexual therapy, like studies that they did.
He did a psychosexual evaluation.
Yes, evaluation. And we went over those. Today, I think we are going to talk about the accusations that were made. I think that's what we had discussed earlier, right?
Right.
Okay. So we're going to bring Christina on with us. Christina is a part of the WTAF team. And we're going to discuss these things. They are very heavy. Just giving another warning that they are very, very, very hard to hear. And actually, some of them don't even seem probable, but you guys can be the deciders of that one. I'm going to bring Christina on or send Christina a link and get her on here, but we will jump over to the documents that I was referencing. Unless, I don't know if you want to jump to that, Amy, or I can pull up the page number while
Yeah, if you'll just tell me what page number you're going to go to, and
okay.
I'll make sure I get there.
Yeah, give me just one moment while I text her.
No problem.
I didn't know she was coming on. Yes.
And while you're doing that, I'll flip back over to the chat since I'm down on a little device here. You guys, we're going to get rolling in just 1 second. This is just... I messed everybody's mojo up with my technological problems this evening, so I apologize. All right. Cynthia Barber wants to know how to become a Patreon. We can drop a link on there. I see Amanda's already beat me to it. When you go there, there's different options. So you can check that out over there. When Danielle was talking about some of the content of what we're about to go over, I'm going to tell you that it's just very graphic. So please just bear with us while we get through it. It is important to hear, though, because it paints a picture of who Lori is.
Yes, absolutely. So let me get to
Kathy Suter. Jay Ryan fought hard for his daughter. Lori's a psycho and social worker psychiatrist said she was out of control, lying, histrionic, destroying father-daughter-son relationship permanently. Totally agree. Couldn't have said it better myself. Let's see. Good God, Lori had Tylee's ATM card while in Hawaii. Tylee was getting her dad's Social Security money and Lori was spending. It's just disgusting. Yeah, when you start putting the pieces together now that we know that they were deceased, or can assume that they were deceased at that time, it's very, very troubling. We actually... Danielle and I were talking about that today, about the Venmo transactions between Tylee's account to Colby, because Lori had Tylee's phone.
Did you know that one of those transactions has since been deleted? Because we screenshotted those in December.
I remember that.
Yeah.
I remember when you guys told me that.
Yeah. And since then, since like the last time we looked at Venmo and screenshotted it, and I want to say it was about 3 weeks ago, one of the transactions is missing, which is crazy.
Can you just... I don't really use Venmo. I have it. I just don't use it that often. Can you edit your transactions?
I don't even know if I have Venmo. I think the only reason I have a Venmo is to look people up on Venmo in cases. I'll be 100% honest. I created one just so I could look up.
Oh, that's why I have LinkedIn.
It started in the Casey Jones case. We wanted to look at some Venmo transactions on Michael Jones's ex-wife. So I created a Venmo, and that's the only reason I have it. I've never used it.
So,
fun fact.
Madam Deficit says that you can make transactions private. So that's probably what happened there.
Okay, that makes sense.
Mm-hmm.
All right, Christina's down there in the chat. I sent her a link if she wants to join. We're going to get to this. Let me find the page number. We have an awesome table of contents that we put together for ourselves, and I have to find the right page to jump to.
Good grief. I'm telling you, I am battling technology tonight.
Oh, this is an interesting one to go to. We'll go to this one.
Okay.
Page 760. Christina's here.
Yay. Okay, I'm there.
Hey, Christina. Yeah, go ahead.
Hi.
I'm going to mute my mic for a second. Hey.
Okay. Let's say hi to Christina too. Hello. All right.
Hi.
Hi. So this is an affidavit, State of Texas, County of Travis. Before me, the undersigned authority personally appeared Sherry Lassiter, who, being by me duly sworn, deposed as follows. My name is Sherry Lassiter. I am over 18 years of age. I am of sound mind, capable of making this affidavit, and personally acquainted with the facts herein stated. I was a juror in the case styled in the interest of Tylee Ashlyn Ryan, a child, cause number D-1-FM-06-004834 in the 345th District Court, Travis County, Texas. Had I known that the criminal charges pending in Hays County were declined prosecution on October 10th, 2007, I would not have voted to appoint Mrs. Vallow managing conservator of the child. The testimony of Detective Scrocky, I'm not sure I'm saying that right, it's spelled S-K-R-O-C-K-I-E, and Mary Fogel, the guardian ad litem, that the pending criminal charges were serious, were prosecutable, and would be presented to the Hays County grand jury the following week, made me believe that if the child was placed in Mr. Ryan's custody, she could later be taken away. It was my belief, and it was the belief of many jurors, that the possibility of Tylee being taken away from Mr. Ryan because of a subsequent prosecution was not in Tylee's best interest. I decided that leaving her with Mrs. Vallow until the Hays County charges were settled, no matter what I felt about her veracity or her parenting skills, was in Tylee's best interest. I have not been compelled, threatened, or coerced to sign this affidavit in any manner, nor have I been offered any bribe or improper inducement as a benefit or reward for signing this affidavit. I am signing this affidavit knowingly, voluntarily, and freely. I have read the foregoing affidavit and acknowledge everything stated herein is true and correct. If called to testify at a court proceeding, I would testify to the same. Further, affiant saith not. Signed, Sherry Lassiter, and then signed by the notary public. So,
that's interesting because the juror, right, had said that if she had known that the charges against Joe for sexual abuse had been no billed, which means that the courts decided not to prosecute him, then she would have made a different decision. And there would have possibly been a different outcome. I mean, I think there's a strong chance there would have been a very different outcome. That's just my personal opinion. I don't understand, and I'm sure it's in these documents somewhere. Christina, you might know. Do you know why the no bill wasn't brought up in the custody hearing?
I don't know why it was. Oh, because during the trial, the day of the trial is the same day it went to the grand jury for an indictment. They no-billed it, and the detective testified that she felt it was prosecutable, and that's why the jurors made the decision they did.
That's interesting.
Wasn't until after the trial that they found out that they went to the grand jury. The detective stated they were going to the grand jury the next week, but they went that same day.
Wow. So basically what she's saying in this, if I'm understanding correctly, is if she thought that there was a possibility that Tylee wouldn't be removed from Joe right away, or the only reason she sent her back to Lori was because she was afraid the child would be ripped back and forth. And then later on, she finds out about the no bill, and she's like, well, wait, I wish I would have known that because I never would have voted to return the child to Lori. Am I understanding it correctly? Yes. Okay.
The way I understand it is if it hadn't been for the investigation, the indecency with the child investigation, the jurors would have made a different decision.
Right.
Or that's the way I took it.
Yeah. Okay.
Yes. And so I think what we want to do is we're going to show you these claims that were made. I just have to track down the page number really quick. You don't know the page number off the top of your head, do you, Christina?
For which one?
For the claims made against Colby as well, or the claims that Colby made and the claims made against Charles's kids.
Trying to think. Do you want the intake interview that the detective originally took when she took the incident report?
I think we went over that in the last one. This would be the one that involves a cup.
Okay, I know what you're talking about.
Okay. And then the one where she called 911 or called the cops and CPS, basically on her own household.
Okay, I know what you're talking about. Give me just a second. Let me find it.
Okay. So all right, we'll jump to, this is the no bill on Joseph Ryan while she's looking for that. So it was published by the criminal district attorney in the Hayes County Justice Center in San Marcos, Texas. And the offense date was August 7th, 2006. The offense was indecency with a child by sexual contact. And the reason for declining is because the grand jury did not return a true bill for indictment. So everything they had was sent to the grand jury, and that would include a lot of stuff in this report, including the guardian ad litem statements and the different psychological assessments that were done, as well as different statements made by minor children at the time in this case. The grand jury did not feel that they could indict Joe and that he could be charged for any type of sexual assault. They failed to prosecute him for it.
Right. Sorry, I'm looking through this as well at the same time.
Yeah.
I thought it was 825, and
that's the reports to the court. We can look at that really quick. I think we went over that one though. Let's see, what is this?
We didn't go over this. We didn't get past like page 252 the last time.
Okay, do you want to go over this page? Or
the one about the cup?
Yes.
Was in the psychosexual evaluation done by Dr. Thorne, and that starts on page 747.
Okay. All right, we'll start there. So
okay. Do you want me to read?
Yeah, if you'd like to, I don't mind. I can read it.
Oh, it's okay. I'll take the first one. Okay. All right. So this comes from Stephen A. Thorne, PhD, clinical and forensic psychology. The address, Austin, Texas. It's dated December 23rd, 2007. It's regarding psychosexual evaluation of Mr. Joseph Ryan. To whom it may concern. I was recently contacted by Ms. Mary Fogel, guardian ad litem, and asked to perform a psychosexual evaluation of Mr. Joseph Ryan. The psychosexual evaluation was initially ordered by the Honorable Laura Livingston on November 2nd, 2007. Upon first meeting with Mr. Ryan on November 30th, 2007, I realized that I had previously evaluated an individual involved in a family law dispute/conflict related to Mr. Ryan's. I shared this information with Mr. Ryan in such a way that did not violate the confidentiality of my former client, though I informed him that I did not believe there was any ethical issue prohibiting me from performing the current evaluation. After hearing this information, Mr. Ryan expressed a desire to continue with the evaluation. After obtaining Mr. Ryan's consent to proceed with the evaluation, I contacted Mrs. Fogel and the attorneys for both Mr. Ryan and Ms. Lori Vallow so that any potential concern about my performing the evaluation could be addressed. After communicating by phone with the relevant attorneys and guardian ad litem, I informed Mr. Ryan that we should discontinue with the evaluation due to my belief that the attorneys for he and Ms. Vallow may disagree about my performing the evaluation. At that time, I informed Mr. Ryan that I would be comfortable continuing with the evaluation if the attorneys could agree on my role in the current matter, or if the court ruled it was appropriate for me to continue with the evaluation. On Tuesday, December 11th, I received an email from Ms. Fogel indicating that the court ruled that I was to continue with the evaluation and I was to have it completed by December 31st, 2007. In performing the current evaluation, it has been requested that I provide an opinion as to whether or not Mr. Ryan displays characteristics consistent with a sexual offender and, in relation, his level of risk for committing a sexually abusive, violent act in the future. It should be emphasized that the current evaluation is not a custody evaluation, and this examiner cannot ethically offer any opinion to what type of visitation, if any, Mr. Ryan should have with his daughter. In addition, this examiner has no opinion as to the psychological functioning of any of the other individuals involved in the current legal matter. As part of the current psychosexual evaluation, I met with Mr. Ryan on the dates of 11/30/07, 12/14/07, and 12/18/07 for a total of approximately 6.5 hours. In addition, as part of the current evaluation, I conducted a thorough clinical interview and mental status examination and also administered a personality assessment inventory, in parentheses PAI, the Hare Psychopathy Checklist, revised second edition, and the SVR-20. Several brief inventories and/or checklists were also administered, including the Personal Problems Checklist for adults, the Beck Depression Inventory, second edition, the Beck Anxiety, time to turn the page, Anxiety Inventory, and the Adult Self-Assessment Inventory. With respect to the collateral data provided by Mr. Ryan, Ms. Fogel, and attorneys for both Mr. Ryan and Ms. Lori Vallow, I reviewed a previous sex offender assessment with family and community risk assessment signed by Vivian L. Lewis, and then her credentials, dated 7/24/07. Psychological evaluations of Mr. Charles Vallow, Colby Ryan, Tylee Ryan, and Ms. Lori Vallow. All of these evaluations were performed by Dr. David Poole in August, September, or October of 2007. Records from Hays County Sheriff's Office, a decline notice from the Hays County Assistant Criminal District Attorney, records from the Travis County Sheriff's Office, medical records for Tylee Ryan, various email communications between Mr. Joseph Ryan and Ms. Lori Vallow, a court's ruling dated 8/22/07, cause number D1FM03002348, in the interest of Nicholas Vallow and Zachary Vallow, minor children, in the 250th Judicial District Court of Travis County, Texas. Photos depicting homosexual and bisexual photos/advertisements. Ms. Vallow's attorney represents that these photos were taken off Mr. Ryan's computer. Portions of a May 9th, 2007 testimony by Mr. Tom Ware and Ms. Lori Vallow, various CPS reports relating to Mr. Ryan and written statements by Ms. Mary Fogel. In addition, in conducting the current evaluation, I have had phone conversations with Ms. Leslie Smith, LPC, LMFT. I also attempted to contact via phone Ms. Susan Shinsky and Ms. Jillian, is that Bonaquisti? Bonacqui?
Sounds great.
Yeah.
We'll roll with that.
It should be noted that prior to the beginning of the current evaluation, Mr. Ryan was informed that this examiner would not be providing any form of psychological treatment and that the results from the current evaluation may or may not be helpful to his legal case. It was further explained to Mr. Ryan that a copy of this report would be forwarded to attorneys for both he and Ms. Lori Vallow, as well as Ms. Mary Fogel. He was given an opportunity to ask questions of this examiner. Mr. Ryan indicated that he understood the information and he agreed to the current psychosexual evaluation. It should also be noted that when reading the current letter, the reader should be aware that due to the need to have this evaluation completed in a timely manner, as well as due to the facts that much of the background history relevant to the current case has already been documented and or discussed, this examiner will not provide the typical background or history section of the evaluation and will instead focus only on various psychosocial factors relevant to the present referral question. As has been well documented throughout the course of the current legal matter, Mr. Ryan has been accused of engaging in sexually deviant behavior with his former stepson, date of birth 04/08/96, and his daughter, Tylee, date of birth 09/24/02. Mr. Ryan's former stepson has reportedly made several outcries indicating that, beginning when he was approximately 7.5 years old, Mr. Ryan, as the active partner, anally sodomized him on multiple occasions over the course of 2 years, and that he also forced him to drink sperm from a jar. With respect to his own daughter, Tylee, Mr. Ryan's ex-wife has reported to officials that Tylee told her that Mr. Ryan crashed into her 2 times a day. Based on information made available to this examiner, including a conversation with Tylee's current therapist, it does not appear that Tylee has made a formal outcry alleging sexual abuse by her father. With respect to the allegations of sexual abuse and or inappropriate behavior by Mr. Ryan, the following information, provided in written form by Ms. Mary Fogel and dated 11/06/07, should be noted.
Okay, let's pause there for a second.
Yeah.
Because
Because that's a huge accusation.
It is. And one of those accusations in there is so unbelievable to me that it would even be accused, because I'm not even certain that it's something that could be done. And I can't get inside this monster's head, because I wholeheartedly believe they're accusations, and we have to believe they were accusations, because the grand jury failed to indict him and charge him for this.
Right. They were false accusations.
False accusations. Yeah. Right. Right. Mm-hmm. And I mean, come on. I mean, this is, where does somebody even come up with this? Where will somebody even come up with the fact that
because she's diabolical and sick and spiteful, and she comes up with the most egregious things she can accuse somebody of. And I think we talked earlier and we said that not very many people could just throw things like this out here. Like, you don't just make this stuff up. You had to read it somewhere, or it had to happen to you.
Right. Right. And Stephanie M., you made a comment that doesn't mean it didn't happen, though. I mean, that's a fair statement to say. It is. However, throughout these documents, it has been noted by professionals that these children were coached, or at least Tylee was coached, because this case concerned Tylee. And Colby became inaccessible. The courts wanted to speak with Colby. They wanted to do assessments and such. And there's a page in here that actually says like Colby seems to be inaccessible every time we try to, get this done or get this done. Something, it just doesn't happen.
Right.
So
right. And I'm not trying to be funny here at all, but she has a history of making her children inaccessible too, because isn't that what we heard about Tylee and JJ?
Right.
Oh, I know where they are. I know where they are. They're okay.
Okay, so Colby did state in his recent interview that Joe sexually abused him. Lori could have made up some additional claims. That's possible. I mean, the only people that know the truth, and I'm not in any way saying that Colby is being dishonest. So I don't want anybody to misconstrue that. I believe that children are very impressionable. And I also believe that Lori Vallow is a very, very calculated. That's not the word I was looking for.
Vindictive.
I think she put fear into her children. I do. I could be wrong. Those are just my opinions. Just my opinions, you guys.
So I think just so everybody's comfortable here, maybe we should say this. We're always going to believe a child, like we are always going to listen to a victim. We're always going to listen, especially a child victim. We understand with Colby, and nobody's saying it's his truth. Okay. And we respect that, and we have to believe him and trust him. But with Tylee, there is documented proof by professionals that she was being coached to say things, and that maybe she didn't even understand what she was saying, because when questioned about it, she couldn't elaborate. And we talked about the other night, right in front of the doctor. She said, I told him, and Lori was kind of shocked because.
Right. Yes. Yeah. Colby, when Lori walked in the room after Tylee was doing a visit with one of the therapists, she looked right at Lori and said, I told them, like telling her mom, I told them what you wanted me to. I did what you said. And Lori's jaw dropped. Again, these are in all of the documents, and you can look back at our last live where we discussed that. I did want to look at this comment up here because it is very relevant, and it is something that we have said in our group. I gotta find it real quick where it went. Carla Cross said, could this be something that happened to Lori? Maybe that's where she's getting this from. That is something we have questioned, because these statements are, I mean, the whole drinking sperm out of a cup thing, you guys, that's something that is not a typical sexual abuse allegation.
Or one that you typically hear. Usually what you hear is, so-and-so touched me in a place where my bathing, or in a no-no spot. If you're using age-appropriate language, or what in your family you consider age-appropriate language. You don't generally hear something that's specific. I think we did talk about the other night that, and this is important, that victims of sexual abuse often repeat the behavior, especially in males, but it happens in females too. And
it does. And Truth Seeker has a valid question, and I don't think that you would be starting anything by asking this. I think it's a valid question, because up until last week, most of us thought that we knew everything in this, like what all there was to know. And then we received this file that literally took our breath away. So,
Truth Seeker, that's exactly what we were kind of talking about.
Yeah, Truth Seeker said, but what if Lori was the pedophile?
Yeah. And she was, because, there's a reason why they say hurt people when you really think about it. It's repeating the abuse. Right. And some of these examples are very, very explicit, and they aren't something that you hear about in after school specials or anything like that. Like my personal opinion, I'm not afraid to say it, is that this is something that you could only come up with if it happened to you.
Mm-hmm. Right. And again, we're not discounting Colby by any means. You know, he's saying that he was abused. We're looking at this objectively. And with all of us having different backgrounds, it just, something's not right. That's my personal feeling.
Right.
So, yeah, and Debbie Schneider said, you believe Colby Joseph Ryan came from a bad childhood with foster care. You know, I don't want to say I don't believe Colby. Do I believe Colby could have been abused? Absolutely, 100%. I don't know. I don't know. I don't understand how a court system would fail to prosecute him if this is what was happening. Right?
Right. So you guys are talking about like some physical signs and things like that. We're not really going to go into that right now. But I think it's probably better if at this point we only speak about Tylee, and we can say with absolute fact that the professionals in this situation and within this document believe that Tylee was being coached. She didn't understand what she was saying. She couldn't rephrase it. It was only, she couldn't, Lori mentioned play therapy. I don't believe Tylee could point out on a doll, like, where things happened, because she didn't really understand what she was saying in the first place. And it was enough where they indicated in the report that they believe the child may be coached.
Yeah, it was indicated more than once. And we're actually going to get to another part as well, because as a mother and as parents, if somebody hurts our children, the majority of us are great parents, and we would do anything to protect our child, right? If we wanted to prosecute somebody for a charge of this caliber, we would do everything, including turning over evidence that the prosecutors asked for.
And Lori didn't.
We're going to get to that page. I got to find the page, guys. No,
it's okay. If you want to find the page, I'll hang back in the chat for a second. Let's see. So let's not make generalizations about people, okay? You can't say that all people that come from one area of the country do this, or the way you grew up makes you this. Because it won't be productive. Can't make generalizations like this. Sky Blue says, this lady destroys everything. Yeah, she does. Everything she touches, everyone she touches. And that's, I think there's so many things that are mind-blowing, but when you go through and you are reading these documents, and a lot of these people that have been long past, I don't know how to say this the right way, but they come to life in this document. And then it's really impactful how many people have died under suspicious circumstances in Lori's life.
Right. And you have to look at the timeline of this. Okay. So these allegations weren't brought until after Colby had not been around Joe for quite some time. Christina, it was like 2 years into this, right? I don't know where she went. Maybe she got off. But I want to say it was about 2 years into this. So this was in 07. The case started in 2005, the original divorce.
Right.
And so Lori first started by saying that she went through Joe's computer and she found gay porn and she took her kids and left. Okay, that was stated. And then 6 months after she meets Charles, then these allegations pop up and the custody dispute just blows up.
Right.
So,
and in the meantime, she was on a campaign for parent alienation like nobody has ever seen.
right.
Because Tylee was confused about who her own father was.
Mm-hmm.
And
Mm-hmm.
I personally believe, again, I'm not a doctor. I'm not qualified. I don't, but I personally believe that the fact that Tylee was confused about her own father indicated coaching too. And that was something that like a psychiatrist or a psychologist or a clinical social worker couldn't put in the file. But if you're telling somebody every day, like, this is your new daddy, that's not your daddy, when they really are, and she's really supposed to be with him, that's coaching in with the intent to alienate. And so that, to me, that establishes a pattern of what Lori does. I shouldn't just use pronouns. What Lori does.
We read this full report, right? And where they said, while psychological testing does not establish that specific abuse acts have or have not occurred, these test findings, in my opinion, are consistent with the allegations and are substantially less indicative of parental alienation. Did you see that? Okay.
No.
Okay. We didn't read these. Okay. So let's keep reading these while I search for the other part that I want. I can read it if you want to look for that part.
Do you know what page that is?
No, I'm searching the document and it's not loading because it's so big.
Oh, okay. I'm just looking if I can match it up.
Where did you stop off at, Amy?
I am on page 749.
Okay, did you finish that page? No, did you finish?
No, I didn't. We didn't even start that page. So I'll go read while you look for the next thing, okay? Is that a deal?
Sure.
Okay, perfect. Okay. Let me just move my mic a little bit here. Okay. There have been sexual abuse allegations naming Mr. Ryan as the perpetrator to Mr. Ryan's stepson and Ms. Vallow's biological son, Colby Ryan, age 11. The case was closed and identified as unable to determine by CPS. The Hays County District Attorney recently took the case before the grand jury, and it was no-billed on October 10th, 2007. Sexual abuse allegations involving Tylee Ryan were reported by the mother, Lori Vallow, naming Joe Ryan as the perpetrator, was closed as ruled out by CPS. The aforementioned statements provided by Ms. Fogel are consistent with information reviewed from available CPS records. With respect to the aforementioned previous CPS investigations, a review of CPS chart note dated 8/14/06 does show the following in regards to a conversation with Detective Scrocky of the San Marcos Police Department. This name, Detective Scrocky, whatever, stated that he observed the videotaped forensic interview of Colby and Tylee Ryan, or Colby and Tylee at Roxanne's house. She stated that there is no reason to believe or indications that anything has or will happen with Tylee, and that there is no information that visits with her father need to be stopped. She stated that her possible case is in regards to Colby, and that she hopes to meet with Joseph Ryan tomorrow to address the sexual abuse allegations. She stated that the concerns that Colby has reportedly outcried to his mom, but there is no physical evidence. The same CPS report also references the following from an 11/13/06 conversation with Susan Shinsky, therapist of Roxanne's house. Ms. Shinsky stated that she has seen Tylee 3 to 4 times. She stated that Tylee does not understand yet why she is coming to therapy. She stated that she has referred to her father on her own, but refers to him as Joseph, which she stated was not normal. She stated that Tylee has not said anything concerning to her. She stated that Mr. Ryan has told her that Tylee has said some concerning things, but that she has not heard them. She stated that she feels that Ms. Ryan may be pushing her too hard to talk, so she was going to speak to Ms. Ryan to back off a little. Most recent CPS documentation also references 3/22/07 and 4/25/07 conversations with Ms. Shinsky. Chart notes detailing these conversations include the following statements. She stated that she is currently seeing Colby and Tylee for therapy due to an outcry that Colby made against his stepfather, Joseph Ryan, in the previous CPS case. She stated that Colby has become more comfortable with her and has been opening up to her a lot more. She stated that during one therapy session, Colby made a new outcry to her involving Joseph Ryan. She stated that all the details are included in the report. She stated that Tylee has not made any concerning outcries to her. She stated that Tylee is starting to become more comfortable around her and opening up, but still has not made an outcry. She stated that she has been asked by the detective if she has any concern with Colby being coached by his mother. She stated that she could see how someone could mistake what he is saying for Colby being coached. She stated that she could not give a definitive answer on whether or not he is coached. She stated that it is her job to treat Colby like a victim, so she cannot definitely say whether or not he was actually abused. She stated that Tylee has still not made an outcry to her. She stated that she is concerned that Tylee is being pushed by her mother to make an outcry. She stated that she has been seeing Tylee since she was 3. She stated that she has told Ms. Vallow not to push Tylee into saying anything, but that Ms. Vallow has refused to take this advice. She stated that her counseling with Tylee has almost become counterproductive and could be a result of her mother pushing her. She stated that Tylee has now almost bottled up due to being pushed too much. She stated that Tylee almost spilled the beans during one session, but then closed up. She stated that Ms. Vallow is very anxious and tied up in multiple legal situations. She stated that this anxiousness appears to be affecting Tylee. And I'll read one last paragraph and then we'll switch off, so it's a good stopping point. It says, it should also be noted that with regard to the outcry made by Colby Ryan, results from the most recent CPS investigation did note the following. The outcry is described as suspect by law enforcement due to the inconsistency in his story. There is also concern regarding the unwillingness of Ms. Vallow to provide law enforcement with Colby's mattress, evidence that could be crucial to criminal investigation. And I'll stop there because that's a lot of information and it kind of backs up a lot of the discussion we were having prior to reading this section.
Yeah. Do you guys have any questions? Anything you want to talk about before we move on to the next section?
What's going on over here? Oh, Doodle joined us. Yay. Okay.
Kathleen Irish, we all definitely pray for Colby. These documents were not released to symbolically be a punch in the face to him. This is truth.
This is about Lori. Your microphone is doing that robot thing, and they're saying so in the chat.
Okay, I'll leave. I'll be back.
Okay. So sorry about that. It's just the way things work some nights, and it's very stressful when it happens to you. So we're sorry. Yeah, the purpose of this is first of all, when you acquire these documents, you don't know what they contain. You have an idea, but you have no idea what exactly is in there. Okay, is it my microphone too now, you guys?
I can hear you fine.
If somebody can tell me if you can hear me.
Is that better?
You sound great. I think they're saying I don't sound good now.
Yeah, StreamYard's going, guys.
Okay.
We're getting rid of it. I've already had a really bad day in other aspects of my life, and I'm not in the mood to fight with a service that we pay for. It's a little.
Okay, they're sounding. We sound really good. The hills are live with the sound of YouTube. Okay, we're good.
All right. I don't know if I can. It's going to take a minute to pull the documents back up. So.
Do you want me to go ahead? I still have it up. Do you want me to go ahead and read?
Yeah, that's fine. Go ahead.
All right. Hold on. Let me just adjust here.
I'm going to go down to the chat and chat for a minute.
You go chat. I would like to go and get my coffee so we can chat. All right. So, continuing on. If you guys want to go back at any time when you get your documents and read, I'm on page 750. Both Mr. Ryan's former stepson and Tylee Ryan were evaluated by Dr. David Poole in order to determine if they displayed various traits, characteristics consistent with children who have been sexually abused. A review of these evaluations show Dr. Poole's opinion with respect to Mr. Ryan's former stepson to be as follows. While psychological testing does not establish that specific abusive acts have or have not occurred, these test findings, in my opinion, are consistent with the allegations and are substantially less indicative of parental alienation. Dr. Poole's opinion with respect to Tylee Ryan is as follows. While the evidence here is that Tylee has been traumatized, the evidence in the testing data is ambiguous and unclear that the sources of her anxiety are the alleged sexual abuse and physical threats by Mr. Ryan. Tylee strikes me as ambivalent about her father and their reinstated visits. But based on this assessment, it is my opinion that such ambivalence could have been caused by negative communications others have made or implied to her about her father, as well as by actual abusive acts and physical threats. If the evidence proves convincing that Mr. Ryan has sexually abused Colby in the past, however, the evidence here of trauma and Tylee's specific apprehensions about violent males killing family members become more compelling as indications that Tylee was also abused and threatened, and that she therefore remains at risk if Mr. Ryan remains unrepentant and in denial. In addition, Mr. Tom Ware, a previous guardian ad litem in this case, testified on May 9th, 2007 as to the following when asked whether he knew of any professional who believes Colby's allegations at this point. I know of no professional that I have spoken to that believes these allegations. It goes from sheriffs, the detective, it goes from the CPS worker, secondhand through the therapist. The kid's been in 9 months of therapy, still nothing. With respect to relevant aspects of his own sexual history, Mr. Ryan reported that he first engaged in sexual intercourse at the age of 18. He went on to state that he had consensual sexual intercourse with approximately 25 to 30 sexual partners over the course of his lifetime. It should also be noted that Mr. Ryan did describe each of his sexual partners as being adult females, with the youngest being Ms. Lori Vallow. She was 15 years younger than him, and the oldest being approximately 7 years older. He was 18 and she was 25. In response to various questions by this examiner, Mr. Ryan denied any history of homosexual fantasies or interests or having acknowledged having any sexual interest in males. He did further note that he considers himself to be heterosexual. Mr. Ryan also stated that he has never admitted to or had any sexual fantasies involving rape and or dominance of a partner. He also denied engaging in role play involving similar themes. He further reported that he has never paid for sexual intercourse. In addition, in response to a question by this examiner, Mr. Ryan did state that he last attended a strip club in 1999. It should also be noted that Mr. Ryan did previously live with an adult female romantic partner who had 2 different male children. Based on his own self-report, it does not appear that Mr. Ryan was ever accused of engaging in sexually inappropriate behavior with either of these children. Mr. Ryan's occupational and military history should also be considered relevant with respect to the current evaluation, as he has indicated that he spent 4 years, 1976 to 1980 in the military without receiving any type of disciplinary action. He further stated that he was awarded a Good Conduct Medal while in the military and that he was honorably discharged in 1980. In addition, based on his own self-report, Mr. Ryan has never been fired from a job. Mr. Ryan was administered the Personality Assessment Inventory, the PAI. The PAI is a 344-item standardized objective measure of psychological and personality functioning that provides information about the test taker's response style through validity scales and psychological personality functioning through the clinical scales. Analysis of Mr. Ryan's response style on the PAI suggests he may have, consciously or otherwise, been attempting to portray himself in an overly favorable light, as there appears to be a tendency towards positive impression management. Mr. Ryan tended to describe himself as being relatively free of common shortcomings, inadequacies, and/or perceived faults across a variety of areas. Such tendencies may result in Mr. Ryan ignoring, minimizing, or perhaps being unaware of some of his own limitations. Such responding styles, it should be noted, are not that uncommon among individuals involved in legal cases. Results from the PAI do suggest Mr. Ryan feels he is being treated unfairly and that others are intentionally trying to cause him harm. Given the acrimonious nature of the current family law dispute, as well as the allegations against him, if they are indeed unfounded, such a finding should not be considered all that surprising. Overall, it is the examiner's opinion that the current PAI results should be interpreted with caution, as Mr. Ryan's reluctance to acknowledge negative or, I'm so sorry, I just lost my place. Okay, as Mr. Ryan's reluctance to acknowledge negative or unpleasant aspects of himself may limit the validity of the current PAI results. Then they did the Hare Psychopathy Checklist, revised second edition. A 20-item scale for the assessment of psychopathy was utilized during the examiner's clinical interview of Mr. Ryan, and he was scored utilizing information obtained from the clinical interview, as well as from a review of Mr. Ryan's available records. The PCL-R second edition assesses the degree to which an individual displays psychopathic characteristics that have been shown to be associated with increased risk for engaging in acts of violent behavior. Mr. Ryan's current PCL-R second edition raw score places him in the very low range of the psychopathic characteristics. It is not consistent with what the authors of the PCL-R second edition characterize as prototypical psychopath. I know this is a lot and it's very wordy, but I think the next two paragraphs are pretty pertinent. So it goes on to say, the SVR-20 or 20 is a set of professional guidelines designed to assess risk for future sexual violence, which is defined as actual, attempted, or threatened sexual contact with a person who is non-consenting or unable to give consent. The SVR-20 consists of 20 risk factors. Of these, 11 risk factors are related to psychosocial adjustment, in parentheses, sexual deviation, victim of child abuse, psychopathy, major mental illness, substance use problems, suicidal, homicidal ideation, relationship problems, employment problems, past non-sexual violent offense, and past supervision failure. 7 items are related to sexual offenses, high-density offenses, multiple offense types, physical harm to victims, uses of weapons or threats of death, escalation in frequency and severity, extreme minimalization or denial of offenses, attitudes toward intervention, and 2 risk factors are related to future plans, in parentheses, lacks realistic plans and negative attitude toward intervention. While there is a possible or partial evidence for the presence of several of the psychosocial adjustment risk factors, Mr. Ryan, based on the available information, does not meet definitive criteria for any of the risk factors regarding sex offenders or future plans. In general, it's the examiner's opinion that the analysis of the data from the SVR 20 suggests that, absent proof confirming current allegations, Mr. Ryan represents a relatively low risk for future sexual offending. With respect to Mr. Ryan's overall emotional psychiatric functioning, a review of the checklists, screeners, and inventories filled out as part of the current evaluation, as well as results from the PAI, do not suggest the presence of any level of confused or disturbed thinking on the part of Mr. Ryan, and his overall reality testing appears to be completely intact. In addition, results from the current psychological testing do not suggest that he is presently displaying any significant emotional disturbance or psychiatric impairment. Furthermore, based on his own self-report, Mr. Ryan has never participated in any type of individual therapy or counseling, nor has he ever taken or been prescribed any type of psychotropic medication. In response to additional questioning by this examiner, Mr. Ryan denied any history of inpatient psychiatric treatment, suicidal ideation, self-injurious behavior, or what may be considered debilitating psychiatric impairment.
Whoa, that's a lot to read.
It was a lot. It's just a lot of information and a lot of like higgity jiggity words. I have to mute my mic for a second because someone's listening to metal detecting videos.
That's fine. I'll go ahead and just keep reading on this part of the document.
Okay.
No, you're fine. I'll go ahead and just keep reading on this part of the document. I'm sure, as you guys can all imagine, this has been overwhelming for us to even try to make sense of. It's been crazy. So, going on, the document says, in assessing the extent of which Mr. Ryan may display characteristics consistent with child sexual offenders, it should be stated that without direct physical evidence of such behavior, it is extremely difficult, if not impossible, for any examiner to determine the veracity of such claims. It should also be noted that there is no such thing as the typical adult male pedophile. And I'm reading from the screen, so you guys are going to have to bear with me as I scroll. Or incest perpetrator. In addition, no psychological test in isolation can tell us whether an individual is or is not a sex offender. Rather, in assessing the likelihood that an adult may have committed a sexual act against a child, any evaluation should focus on the extent to which an individual has displayed behavioral manifestations commonly found in pedophiles, including a history of sexual deviancy, antisocial orientation, and criminal versatility. With that caveat in mind, it is this examiner's opinion that Mr. Ryan does not display the majority of the characteristics commonly observed in child sex offenders. To begin with, it should be recognized that Mr. Ryan does not appear to have a history of criminal convictions relating to sexually inappropriate or violent behavior, nor are there apparently any findings by the Texas Department of Family and Protective Services or any appropriate governing body that indicates Mr. Ryan has ever physically or sexually abused another child or adult. Based on the information made available to this examiner, there is no history of violent behavior as a child, an adolescent, or adult on the part of Mr. Ryan. Furthermore, Mr. Ryan does not appear to have a history of severe psychiatric disturbance or impairment. Example, persecutory delusions or thought control that in an acute state may increase the likelihood of impulsive behavior, impaired reality testing, or poor judgment. In addition, with respect to the allegations of sexually inappropriate behavior involving his children, Mr. Ryan does not report, or to the best of the examiner's knowledge, have a documented history of sexual interest in children or adolescents, and has Based on the information available to this examiner, all of his sexual partners have been adult female partners. There is no information available suggesting that Mr. Ryan views or has viewed child pornographic material or sexually violent pornographic how do you guys say that? Sadomasochistic material? Mr. Ryan does acknowledge a history of viewing what he describes as regular straight and lesbian pornography. And further, reviewing relevant aspects of his sexual history, it does not appear that Mr. Ryan has a history of impairment and or the ability related to successfully pursuing heterosexual involvement with women of his own age. There is also no information available suggesting that Mr. Ryan has attempted to acquire jobs that bring him into consistent contact with children. In addition, based on the available information, there is no apparent previous history of sexual attraction to children, consistent deviant sexual desires, cognitive distortions relating to sexual activity, or any other type of behaviors consistent with those individuals meeting diagnostic criteria for a paraphilic disorder. Specifically, based on information available to this examiner, Mr. Ryan does not appear to have a history of behaviors or activities related to exhibitionism. I can't even say that word, I'm all.
Exhibitionism.
There you go. Mr. Ryan, I'm sorry. What's the next one, Amy? Fraudage? Is that how that's pronounced? I feel really stupid right now.
Don't feel stupid. I'm not quite sure where you are.
We're going to go with fraudage.
That one I don't know.
Yeah, I've never seen that word before. Voyeurism, transsexualism, transvestitism, sadism, or masochism, public masturbation or fornication, bestiality, or coprophilia. It should also be noted that many confirmed pedophiles have a large number of victims, and that when an individual is falsely accused of pedophilic behavior, there is frequently only one victim who is even considered to have been abused, though there are allegations to alleged victims prior to the current family law dispute there have apparently never been any other allegations of sexually abusive behavior on the part of Mr. Ryan. Mr. Ryan, it should be noted, does exhibit some behaviors or characteristics commonly seen in individuals who sexually abuse children, including a lack of close emotional attachment with his mother as a child, a history of some illicit substance abuse, and a history of criminal convictions resulting from the use of alcohol. Specifically, in conversation with this examiner, Mr. Ryan acknowledged having a rather limited or strange relationship with his mother growing up, and he described living at different times with relatives in orphanages and in foster homes. In addition, which he stated that he was never sexually abused as a child, he did describe experiencing a little bit of physical abuse by his mother. With respect to aspects of his criminal and or antisocial history, Mr. Ryan did acknowledge being arrested for a DWI at the ages of 22 and 29. When further discussing these previous arrests, Mr. Ryan stated that he received deferred adjudication for both charges and that he did successfully complete the terms of his probation on each occasion. Mr. Ryan did also state that he was arrested in May of 2007. When asked about the circumstances of the arrest, Mr. Ryan stated, just recently when Lori made the allegation that I hit her in the courthouse. With respect to the acknowledged prior substance abuse, Mr. Ryan described having previously used both marijuana and amphetamines, though he denied having used any type of illegal drug since the age of 29. We're going to take a break there for a second, because these documents are hardy and
Heavy.
Yes.
Heavy.
Somebody said if they don't know a word, they look it up. I usually do too, but I'm like working with my phone, StreamYard, and looking at a shared document, and I don't have any more.
Well, we did
resources.
look it up. Somebody down in the chat looked it up. I was typing at the same time she did. It seems like it said, actually, well, the definition is the practice of touching or rubbing against the clothed body of another person in a crowd as a means of obtaining sexual gratification. And the pronunciation is like frottage, I guess.
Okay. I was close for never seeing a word before in my life.
Well, wait. Here we go. I can
scroll up.
I don't know. Crazy.
Thank you, Arrow. That's kind of you to say. Thank you. I'm gonna look at some of your guys' comments. Let's look at some comments. And
that's it. Listen.
Frottage.
Oh gosh, how did you do that? You never cease to amaze me.
Oh, it's just dictionary. I'll pronounce it for you.
Amy's got all the answers for me, you guys. When I don't know them, she's like, "Oh, I know that." I didn't even know dictionary.com talked.
And you do that for me too. That's why we're a good team.
You learn something new every day.
You do. You taught me something new just the other day.
I'm gonna be using that all the time to tell me how to pronounce words. Alma asks, did Colby say that Ryan abused him? Yes. Let's see. ACM, were there medical examinations done to verify abuse? I don't believe.
Okay, on Colby, there were examinations, and they did not have. It said in the document a couple pages back, there was no physical evidence of sexual abuse.
Okay.
And that was referring to the. I'm sorry, but to the anal penetration. So.
Okay. Poppy's in Normandy. I agree with you. Joseph Ryan sounds like a typical male. He does. Jan Thurgood said the same thing. He's just a typical man. So sad. Humanimal said same. Again, normal.
Sorry. Fondue or fromage. It sounds so much like fromage. Like when you're cooking, like cheese.
Yeah.
But it's not cheese, folks. Nope.
Yeah. There's so much information in here. So much. Honestly, it makes my head hurt.
It's when you all start reading it's I don't know another way to explain it except it's very, when you realize that these are real people and people we've seen pictures of, and we know their ultimate demise is probably not the right word, but the outcome for them, it's very disheartening, and it weighs on you because your mind keeps going back and trying to put the pieces back in chronological order, because we know how it ends. We just don't know how it began.
I'm sorry. I'm behind on the chat, and I just saw something that cracked me up.
Kick them in the goalies?
No, Madame Deficit, you never cease to make me choke when I'm taking a drink of my Diet Pepsi. On here.
What did she say? Can you repeat it?
I'm not going to. It's funny. It's not bad. It's funny. It just made me laugh. I already scrolled way down, and
Rats.
Truth seeker, yes, it's overwhelming and draining. You guys. Hi, Amy. How do you? I'm going to find this comic because it was funny. How do you say that word again? Frottage? Did I say that right?
Hold on. Yeah.
This one, because this one you just cracked me up, snow remover.
Snow remover. Are you friends with 1 Hour Dry Floors?
1 Hour Dry Floors was in here yesterday.
Frottage.
See? Frottage.
Yeah.
A frottage à trois? Oh. Oh.
We better stop because people will think
Yeah.
we're making light of a serious situation and we're not, because this is just our personalities.
No, things get so intense, and you need I don't really want to say release because that's terrible too, but you need a way to let it out.
You guys are not disappointing in the comments, so let me tell you, you're totally. I was having a really bad day before we came on here, and now I'm like some of these comments, and in no way is anybody making fun of the situation.
No.
It's just humor back and forth between chatters.
Lynn Fox, if Lori didn't kill Joseph, going through this stuff would be enough to give him a heart attack. That's for damn sure.
I am going to put this comment up because this is my favorite YouTube troll of all time.
No.
Nope. Madame Deficit has asked where Shoot the Moon has been. I would like to let you know that I have 8 Shoot the Moon accounts blocked. So we're just waiting for the 9th one to pop up. Yeah.
They usually asexually reproduce rather quickly.
Those trolls, yes, they do.
They do. They're like gremlins.
Patricia Beckman, you make a very good point. This is why doctors and emergency workers have such a sick sense of humor. You have to. That's honestly probably why my sense of humor is the way it is too. I'm not a doctor, but I'm in that medical field, and sometimes you have to just, if you didn't laugh, you'd cry.
When I was 18 months old, I fell out a 2nd-story window into some bushes, so maybe that's what happened to me. True story.
Oh, Amy. You're hilarious.
Don't look up coprophilia. I had no idea what that was. Oh, I smell a dare.
Oh, gosh.
Oh, gosh. I won't say it out loud, but I'm going to look it. I can't stand it.
True helper. You're not a doctor, but you can say that some suffer from ass in the brain syndrome. Jan, your son's a mortician, Jan. Oh, yep. You have to have a sense of humor because. She looked it up, you guys.
I have to go brush my eyes. Oh, yikes.
Okay, so hi, Open Minds. Is Christina still there? She's muted.
I don't know if Christina's still there. I see her little floating head, but I don't hear her.
Oh, wait. Oh, my gosh.
What?
Sorry, Christina. I forgot to add you to the stream. I'm sorry.
That's okay.
Oh.
Why didn't you text me?
It's okay.
Oh, she was trapped in the car, scratching at the window, honking the horn.
Don't ever let me do that again. I'm like, why isn't Christina talking? Okay, so where do you think we should move on to next? I guess we could keep reading this.
The bedroom incident is on page 1080.
Amy, do you want to address this comment from Not Norman's mother?
Sure. How is the how is the release of these documents not a HIPAA violation? Well, I'm not an attorney. I can't really comment that. What I can tell you is that when the agency sent these to us, none of this stuff was redacted. So they were okay with it being released to the public. So that was their interpretation of HIPAA.
Right. I'd also like to point out that all of these records are part of a legal court document. Does somebody have their YouTube on in the background by chance? Either of you?
No.
No? Okay. Yes, April Parker, these are not medical records. These are official court records, and the things within these court records became part of the permanent court record. So there's no HIPAA violation. We didn't steal them either. I'll just say that again for like the 50th time.
Don't have document gate, valor gate. But I'll just confess, I dressed up in a cat suit and I broke in the middle.
Jessica A., this is not our first video on these documents. We have a previous live done on these documents.
What page were we supposed to go to, please?
Did you want the bedroom incident?
Yes.
Okay, that's page 1080.
Thank
Okay.
you.
We can keep chatting while I get it to page 1080 because I did not compress the file before we got on here. Let's see. Let's look at comments. Yeah, I hear it too, Goofy Jen. I hear myself in my headphones talking. It's weird. Watermark gate.
I've had my mic muted, so it's not coming from here.
It's weird. Robin M., you are correct. Public records that were apparently not asked to be sealed during the court proceedings. Did it get me to page 1080? Yes. I think it did. Do you want to read this? I'll read it.
I don't mind reading it.
Okay.
Yeah.
All right. Let me mute my mic.
Okay. All right. Here we go. Let's see. Of course, I said that and I just hit a button. Give me 1 second here. Okay. This is a motion to modify. Now comes Joseph Ryan and files his motion to modify the existed. I need a drink. Hold on 1 second. Now comes Joseph Ryan and files his motion to modify the existing judgment regarding possession and residence, and in support thereof would respectfully show the courts as follows. 1. The order to modify is the final judgment signed this year after the jury trial in 2007. In that judgment, Lori Vallow is given sole managing conservatorship and the right to designate the child's residence. Since the jury verdict, the rendition, and the entry of the decree, circumstances have materially and substantially changed, and a modification of the primary residence of the child should be changed. Number 2, Lori Vallow, present sole managing conservator, has complied with the court's orders in a reasonable fashion. She has frustrated the court's orders for a treatment team and has not. Hold on. I messed up, and I'm so sorry. Lori Vallow, present sole managing conservator, has not complied with the court's orders in a reasonable fashion. She has frustrated the court's orders for a treatment team, has not scheduled meetings with the team, and has not made payments in a timely manner to the team members. As a result, the team did not really begin work for 2 to 3 months after the court's order set up the team and began its functioning. Item 3. Dr. Laredo has appeared in court more than once pointing out these concerns. The court has specifically ordered Ms. Vallow to make payment to Dr. Laredo at specific times, and she has failed to do so according to the reports received by Mr. Ryan. The treatment team has complained that she is inaccessible and has requested that she return to Austin from Arizona to where she says she has moved. Number 5, Ms. Vallow has lied about Tylee's medical condition in order to skip a visit with Mr. Ryan. Ms. Vallow has failed to notify Mr. Ryan in a timely fashion of serious medical problems and hospitalization of Tylee. She and her attorney have continued to label Mr. Ryan a child molester. Number 6. Meanwhile, Tylee has been seeing her father on a continuingly more open basis. Number 7. Ms. Vallow has now reported to the court and the Child Protective Authorities that her stepson was recently in Tylee's bedroom after she went to sleep and that the boy was masturbating. According to the report of Cheryl Wheeler, the boy's mother, both Ms. Vallow and Mr. Vallow said to her on the telephone that they knew that the child was in Tylee's room. Under the circumstances of this and the Vallow case, it is difficult to understand how Ms. Vallow could have allowed Tylee to be alone with a 12-year-old boy after dark while she was in bed asleep. Number 8. Meanwhile, according to reports, Mr. Vallow has assaulted Ms. Hindira, the wife of his lawyer, and Ms. Vallow's lawyer in the 2 custody cases. Number 9. The continuing chaos and sexuality at the Vallow house, along with the noncompliance of Ms. Vallow and the treatment plan, constitute an emergency, and the court should issue orders instantly removing Tylee from Ms. Vallow's home. Mr. Ryan should be named the person with the right to name the child's primary residence, and the court should issue residence restrictions about Tylee to keep her available to the treatment team and her father in Travis County. It was a lot. Do you want me to go on and read 10? Because then we'll complete this document. Item 10. It was necessary for Joseph Ryan to secure the services of J. Terry Weeks, a licensed attorney, to pursue and protect his rights in the suit. Judgment for attorney's fees, court costs, and expenses should be awarded to Joseph Ryan and against respondent, or, in the alternative, such attorney's fees, court costs, and expenses should be taxed as costs and ordered paid directly to the undersigned attorney. Wherefore, premises considered, Joseph Ryan respectfully prays that the court modify the existing possession and residence orders in this cause and the designation of the sole managing conservator. He prays that the court, on temporary hearing and on final hearing, will declare the parties joint managing conservators and give him the right to establish Tylee's principal residence in Travis County, Texas. He further prays for attorney's fees on temporary hearing and on final trial of the cause. He prays for the issuance of additional orders for the protection and welfare of Tylee as may appear appropriate at a hearing. He further prays for all other and further relief to which he may show himself to be justly entitled, either at law or in equity. Respectfully admitted, J. Terry Weeks, attorney at law. And then it is signed by the attorney. And on page 1084, it wraps with the certificate of service. And then that brings us to page 1085. And this is an affidavit of Joseph Ryan. It's basically a one-page deposition. So,
is there anything anybody wants us to look for in here or specifically discuss? Because we actually are going to do a full read through, I believe, aren't we, Amy?
yeah.
From front to back of this. We're going to do it in segments. And it's just going to be a read through. So is there anything you guys want us to look at?
I think earlier today, Christina did a really good job of clarifying the attack of, let's see, when, let's see, it was down further. When Charles's, when the fight in the parking lot with the attorneys. Do you remember us talking about that earlier today?
Yes. Yep. Christina did a great. I don't know if Christina wants to explain it now, or we can break it down and explain it.
It's fine. Hold on. Give me just 1 second here. Because I don't know why. Like this thing right in front of me, I can't seem to find it. I just read it. Stupid.
Oh, see, Mama, that's gonna be coming, not in this document. Christina, can you hear me?
Yeah, I can hear you.
Okay. Okay, we're just waiting on Amy.
Well, I was just gonna look at. We had put. It was in a text. I was just gonna pull that up, but
Yes, Annie. The attorney Lori said came to her and talked to her after his death is Terry. That was, I think, in our last live. She said, one of the concerns with Lori was that she believed Tylee was her reincarnated sister Stacy, and that her lawyer came and spoke to her every night. Her dead lawyer visited her every night.
She had visions and she communicated with the deceased. Yes.
Yes.
Why was Charles' son choking? Oh, okay. I can't. Nothing. I should just be very careful about reading blind comments. Not because you offended me, but because I don't want to say that.
Right. Somebody asked what Joe had to pay in child support. Mama D, my friends, Joe paid. It started out at $2,500 in child support.
Yes.
And I believe at the end of this, he was paying around $1,000.
So Maui Girl says, I can't imagine what these victims went through. I'm exhausted just listening to all these accusations. When I read this, I think how broken down Joe must have been, not only emotionally, but financially.
Right.
It was just never ending, just over and over and over and over.
Annie, we do not know how that attorney died, but we will find out. That's a good question, actually. Yep. We do not know. I don't think we thought to look into that, did we? I guess we should have thought to look into how Lori's attorney died. Yeah, probably natural causes, Goofy Jen said.
It always is, right?
Yes. Stacy DN, Texas. She said it was Charles's son. Are you referring to the incident with Tylee in a bedroom? Is that what you're referring to? Yes. Yeah.
Arrow says, make no mistake, religiosity is always cause for concern to mental health practitioners, not being religious, being hyper-religious, and believing oneself to be chosen. Right.
Lori actually tried to suppress her religious beliefs from the trial. She tried to have that suppressed. She tried to have anything that did not paint her in a favorable light suppressed.
Well, she should have just done that with her mind. She was very powerful. She just made that happen. Yeah, she's clearly. Do we know which boy was in Tylee's room? It was one of Charles Vallow's sons.
Yeah.
Allegedly,
and I don't think we're gonna say his name because
and I don't think it needs to be discussed ad nauseum, because what we need to constantly remember is that these are accusations that Lori made. Okay,
right?
These are accusations. So,
see, Mama, that's a good question. Why was Lori not ordered to have a 7:30 evaluation? I can't figure it out. I can't figure out how Lori got these kids or how she got Tylee. I understand how she was able to keep Colby because Colby was not involved in this custody dispute because Colby was not a legal child of Joseph Ryan. So the custody dispute was solely over Tylee. I cannot believe that Lori walked away from this with Tylee. So, is that you typing, Amy?
Yes, I'm sorry. Let me mute myself for just 1 second. Actually, I won't mute myself because I won't even type this. Glowing Ember, I adore you, and I'm looking at your comment right now. We know who these people are. We're not going to say them because they are still alive, thank God. And these are allegations. So we're just not going to talk about them. We had to read them because it was part of Lori's accusations. But
right. So I don't know what else. I mean, there's a lot in here. A lot.
There really is. Do you guys have any questions? I mean, I have Christina very graciously made a little reference sheet for what's in certain parts of this document. And I can pull that up and kind of give you an idea if you have any questions. No?
Let's see. I don't know. What did Annie say?
She was talking about her bankruptcy attorney.
Oh, I didn't know that. What? She told her friend that it worked out well for her because she owed him a lot of money?
Sorry.
What portal did this bitch come out of?
Oh,
I mean, literally, where did this person come from?
I don't know, but she's got like a 4-foot ironclad bulletproof veil.
She's so into reincarnation. Like, I seriously believe she is the reincarnation of the devil.
Mm-hmm. Yeah. I agree.
Her current attorneys better be safe. Good Lord. I'm a little concerned for oh no, that's the prosecutor that looks like Charles.
Mm-hmm.
Yes, ACM, that is a good thing to point out. She was able to adopt JJ because it was a family member adopting to another family member. I was under the impression, though, that even when you did kinship adoptions, that there was still like home visits and things were still checked out. I don't know. I could be wrong. I don't know very much about adoption at all. I get it, Goofy Jen. They're going to be up on Patreon. We had made a post, and actually that was specified yesterday when we put our Patreon up, that the documents would be released as soon as this live was over, depending on what tier on Patreon. And another thing I kind of want to address, this isn't like, Vallow related. I guess it kind of is because our documents were hijacked and watermarks were taken. We never wanted to put documents on Patreon. We never wanted to have to go that route. And we are looking for a solution to that. So everybody that has bought or became a patron, we greatly appreciate that. Our hope is that it will only be for the 1 month right now because you have to do it month by month. So.
Right. Yeah. We're hoping that we find another solution and we're only using Patreon for the month of July. I think that's kind of where we are right now.
Okay. Wendy Johnson from Facebook, because this is going to Facebook too. She says there is regulations for adopting from, family. She adopted her husband's daughter. I'm curious to know. We're gonna have to look that up and see what the kinship rules are.
Mm-hmm.
Thank you, Dawn. Your sense of humor is in sync with everybody else. Okay. So we've been on here about 2 hours now. And unless there's anything anybody else wants to discuss, we can wrap it up. We can go release the Patreon, the first tier that is due to be released tonight. And I'm going to reach out to a couple. I got to reach out to a couple people.
Yeah, definitely. We have a little bit of housekeeping to take care of after this. Yeah.
Nicole, yes, the 1,771 page page file is in chronological order of when they were filed in court.
Mm-hmm.
It is a huge file. Huge. Jen Kelly, no, somebody in the chat coming from Facebook saying that there is protocol in place when you do a kinship adoption. Because I had questioned, I wasn't sure like what the protocol is when you do a kinship adoption versus when you do a private adoption or through an adoption agency.
Right. We were just questioning whether or not they'd have a home study, do a background check, all of those things that they do in,
Right.
Typical, because it seems like with all this back and forth and a pattern of behavior and some of the accusations, it's no matter where, I'm not trying to be funny. It seems like wherever Lori Vallow is, there's murder and sexual abuse. So I don't know why you would allow another child into that home.
Yeah. And when you go through these documents, there was also a permanent injunction put in place that Charles could not be present at the exchange of Tylee. Because there was, and I know that's a little off topic from the adoption, but that was put in place in these documents because there were multiple there was the assault in the courthouse. There was tailgating Joe Ryan when he had picked Tylee up. Charles hired somebody to tailgate 2 vehicles to tailgate Colby. Oh my gosh, Charles, when he had Tylee. There was all kinds of things that happened. And yeah, I have to believe, and I do believe that Kay had no idea about any of this. Suzanne Murray, that is correct.
Right. There should have been an injunction against Alex after the tasing. You would think so. There's a lot of things that should have happened.
Oh, somebody else noticed this too. I'll put this up here. Yvette Rangaluccio. So you saw the No, I want to just clarify. So the documents that you're seeing, those are the ones that we published publicly on Twitter and our Facebook group. So the watermarks were lifted.
Mm-hmm.
That's what that was. That's why we went to Patreon.
Right.
So
it's this whole thing has been difficult for both of us, for the whole team. So forgive us if I get edgy and it's hard. It's just really hard. I totally get where everyone hates Lori. I absolutely do. However, I have a hard time thinking she was always the killer. I believe she was definitely brainwashed, which doesn't go well with narcissism. Interesting.
It is interesting. What else is interesting is every man that she was married to filed divorce from her.
Mm-hmm.
So, and the first 2 seem to have took off and headed for the hills and got the hell out of Dodge.
She was still standing in the dust. Don't you?
Right.
Yeah. Meeting
Right.
husband number 3. Yeah.
Nashville, Tennessee. I will drop the Patreon link right now. We do ask that on our Patreon, this is information that is available to our patrons only. So sharing the link outside of Patreon is
disrespectful and frowned upon.
It is, because it actually is disrespectful to other patrons. So we ask that if you join our Patreon, you do not share the link to the documents and that you respect our Patreon rules. So I don't know. Christina, do you have anything you want to add?
Did you discuss the Arizona incident at the Barnes and Noble?
No, we did not.
That might be something they might want to hear.
Okay.
Just because of how aggressive it got.
Mm-hmm.
And that Joseph Ryan lost the rest of his visitation for a few extra days because Lori lied to the cops.
Do you have a page number for that?
I do. It is. Hold on.
No worries.
Pages 1,332 to 1,334.
Oh, that's not bad. It's not bad.
I mean, I think the beginning of that document is mainly just like an order that was put in place.
Right. Okay, hold on.
And I want to say the middle page might have the incident.
All right, I have it up on my screen. Hold on 1 second. Let me just. I never thought I'd say this in my life because Christina and I both know how blind I am. It was too big. So, 1,332. Okay. So original petition for breach of Rule 11 agreement and rescission. And the plaintiff is Joseph Anthony Ryan. The defendant is Lori Vallow. And it says, facts. Attached to this petition as Exhibit A is a copy of the transcript of a Rule 11 agreement announced in court on July 17th, 2009 by defendant's counsel Judy Leecraft, pursuant to her authority as counsel for defendant Lori Vallow, and also agreed to by plaintiff herein, petitioner in the other cause, and approved by petitioner's attorney to fully and finally settle plaintiff's motion to modify that was set for jury trial to begin on July 20th, 2009. The agreement is incorporated into this petition by reference. Plaintiff has fully complied with the terms of Rule 11 agreement. Let me see if I can get down to where we need to be here. Okay. So number 5, right underneath that is titled Default. And just 9 days after the Rule 11 agreement was announced in open court before the Honorable Associate Judge Shepard, defendant defaulted by prematurely and summarily terminating plaintiff's summer visitation with his daughter. The summer possession by plaintiff of his daughter was the material term of the Rule 11 agreement. The history of the underlying case is that the defendant is carrying on an endless campaign to alienate him from his child. In the process, she has lied about many facts that were used to obstruct and prolong plaintiff's separation from his daughter. On a prior occasion, defendant or her agents had hired 2 men to tailgate plaintiff, who was with a chaperone and his daughter on his first visit to his home in over 2 years for an overnight visit. The vehicle was a dually pickup with a menacing cattle guard on the front. The incident frightened plaintiff to the point that he called the police. Prior to this incident, defendant's agent, her brother Alex Cox, assaulted plaintiff with a taser-like weapon in the parking lot at a kids exchange on plaintiff's first visit with his daughter in 18 months. Defendant's brother was subsequently arrested and pled to probation for felony aggravated assault. In the latest incident, defendant was meeting plaintiff and the child at the child's request at a Barnes & Noble bookstore in Gilbert, Arizona. Upon his arrival, and as they entered the store, to plaintiff's surprise, defendant was accompanied by her husband, Charles Vallow, and an unknown male. Charles Vallow, defendant's husband, is the same person that defendant in a deposition testified had hired the two men to tailgate the plaintiff's chaperone, and the child as described above. On arrival at the Barnes & Noble in Gilbert, Arizona, Charles Vallow immediately grabbed the child's arm and simultaneously began using his iPhone to take pictures of the encounter, all in an intimidating manner. Defendant participated by using her body to shield the child from the plaintiff. The Vallows' collective actions caused a public disturbance in the entrance of the store. The police were again called, and respondent represented to the police in Gilbert, Arizona, that on July 26, 2009, she had a superior right to possession of the child in spite of the Rule 11 agreement. Her false statements to the Gilbert policemen are just one of many lies she has made to deny and obstruct plaintiff's visitation with this child. Due to defendant's lies, the child was removed from plaintiff's possession by the police. All this commotion occurred in the presence of the plaintiff's daughter. Furthermore, defendant has moved to Maricopa County, Arizona, while the motion to modify case is still pending, which the violation of the Travis County District Court's standing orders. The Rule 11 agreement, there's a typo here. The basis of this lawsuit was agreed to by the plaintiff and the belief that they are agreeing to a compromise all issues between the parties would be settled. Among the terms agreed to, one term states that the plaintiff would move to or make himself available in the Maricopa County, Arizona, in several months following the Rule 11 agreement. I'm going to apologize to you all. For some reason, in this particular section, there is a multitude of typographical errors. The events that took place on July 26, 2009, combined with the prior intimidating actions by defendant and/or agents, including defendant's brother, who now lives in or near Maricopa County, Arizona, had made the agreement to move to Arizona impractical given the potential for future violence on the part of defendant, her agents, or those affiliated with her. Plaintiff is concerned what he might do, including the use of force, if these brazen and harassing actions persist. Based on past behavior, the brazen and harassing actions will never cease until a court forces them to stop by taking a coercive action. Enforcement of the agreement is not possible, and the sole remedy to make plaintiff whole is to rescind the Rule 11 agreement and order the parties immediately to trial on plaintiff's motion to modify and let a jury determine the best interest of the child. Let's see. Furthermore, on or about August 20th, 2009, respondent's attorney notified movement that respondent was not going to perform a complete audit of the arrearages owned by movement to respondent, which is the breach of the terms of the Rule 11 agreement. Let's see. The agreement, as announced in court, sounds as this defendant is the instigator for a judgment for child support. The demand for an audit was made by plaintiff based on evidence that was produced at defendant's deposition in the presence of defendant's present attorneys. This gets super, super wordy, and I'm not really sure this is... basically, it says, plaintiff audit shows that plaintiff has overpaid his child support arrearage. Rather than credit the plaintiff for the two checks, defendant argues the last final order has a judgment for child support arrearage, and the two checks that are not credited to the plaintiff account occurred before the judgment and therefore moot. So she's saying, those are just free checks. The reason plaintiff entered into the Rule 11 agreement was to close all outstanding issues and conflicts between plaintiff and defendant and share their child. Again, enforcement of the agreement is not possible, and the sole remedy to make plaintiff whole is to rescind the Rule 11 agreement and order the parties immediately to trial on plaintiff's motion to modify. So, it's just it's basically just signatures and stuff when we get to the end. I don't know. I'm going to be honest. I don't know what the Rule 11 agreement was. So
it's in the documents, and the patrons will be able to access that. And we are, again, we don't want to limit anybody from being able to hear these documents. So we are going to do a full read through. And cover every square inch of them.
right.
I don't have the ability to type and insert. It won't let me do it for some reason right now. So, or I would. I feel like I know the Rule 11 agreement, but I've read so much and I don't have it in front of me. So
I don't know that page number.
Yeah, I don't know. I've read it. I
I've read them all like 100 times. I just don't know what page it's on right off.
Right. So with that, I think we are going to probably wrap it up pretty soon, guys. Is there any other questions or anything anybody wants clarified of what we did go over? Let's see any. No questions. So, all right, everybody, I guess, who has signed up for Patreon based on your tier levels, they're scheduled to be released, all of that good stuff. And we will again be going through the entire case file piece by piece by piece.
Annie has a custody question.
Yeah. I'll have to look and dig and get back to you, Annie. Because I believe it's something else that we're waiting to come through. This case was transferred, correct, Christina?
Yes.
Yeah. So that's an answer. We're waiting for that answer to come through. I want to give a huge shout out to all of our mods down there. You guys are amazing. Could not do this without you, seriously, because it would be impossible. So Amanda, Madame Deficit, who else was down there? Doodle, True Helper. Let's see.
Amanda Clampett, Amanda Northcutt.
Yep, Amanda Clampett, Amanda Texas Girl.
Iris.
Yeah, True Helpers down there. Thank you. You guys are awesome. And to everybody who supports us, all of our subs, everybody here tonight, thank you for being here. Thank you so much for the super chats. I'm at a loss for words. Also, Trisha from Web Sleuth was down in the chat. We have a collaboration coming up with her next week. That should be a good collaboration, and we have a lot to discuss with her.
Looking forward to it. And I don't know if we talked about it at the beginning because I kept getting kicked off or whatever, but we were really excited today to be mentioned by Crime Online. And
I can clarify this one question really quick. Kathleen Irish said, please clarify why you protect the name of Charles Vallow's son, but you didn't redact anything to protect Colby. I think you guys are reckless with the innocent living. Well, to be fair, these are public documents. We did not write them. We did not release them. The courthouse released these. These are public. We're not responsible for what is in them. And I don't believe the child's name was stated.
It was not.
It was not stated.
It's not stated in any of the documents.
Correct. Charles Vallow's son's name is not stated in any of the documents. So we weren't doing anything to be reckless. And that's that.
Right. And we are not, when you receive a document, if the agency releasing it to you redacts something, that's their decision. Once they're given to us, we feel like we have to give them to you like we got them, because otherwise we're accused of manipulating them, and we only bring you what's authentic.
Correct.
So
Correct.
we can't pick and choose the truth. And the truth isn't that anybody did anything. The truth is that somebody told a story and it was entered into court record.
Correct. So on that note, we're going to end this. And
good night, everybody.
Yeah. Thank you, Christina, for coming on. Good night, everybody.
Good night.
Everybody have a good night. Bye, guys.